Greetings to all students. Today we are going to discuss an important topic, and that is emergency provisions in India. This topic can be discussed under following headings: Introduction, Federalism and rationale for emergency provisions in India, National emergency, State emergency, Financial emergency, emergency provisions, criticism, suggestions, and finally conclusion. The system of emergency provisions in the Indian Constitution is a distinctive feature of it. Federal system of governance has been adopted in India. The emergency provisions under federalism provide a new dimension to the center-state relations in India and make the center more powerful than the states. But at the same time, they also express the concern of the framers of the Constitution, which was about national unity and integrity. Certainly, Indian federalism can be understood in true sense only by studying emergency provisions. Students, as you know, we have accepted federal system of governance in India. But when we talk about federalism in India, it becomes necessary to mention those emergency provisions which have huge impact on center-state relations, and they are also concerned with the integrity and unity of our nation. So, I would say it is very important to discuss these emergency provisions if you want to understand the character of Indian Constitution. Federalism and rationale for emergency provisions in India. The federal government system has been adopted in India, under which a central government and several state governments run the governance system in their respective regions using the powers conferred by the Constitution. One of the main features of the Indian Constitution is that in times of crisis of emergency, it converts itself into entirely unitary state. Students, you might be aware about the federal system in which there is one union government and several state governments. An important thing here is to note is that both the governments function in their respective fields which have been defined by the Constitution. In India also, these powers have been divided according to the provisions of Indian Constitution, but most important thing to note here is that at the time of crisis, the Indian Constitution converts itself into unitary government. A unitary system of governance is that system in which whole nation is governed as a single entity, and if there are subunits, the powers to them is delegated, not decentralized. So, they have to work according to the directions from the union government. The term emergency may be defined as a difficult situation which arises suddenly and demands immediate action by the government under powers especially granted to it by the Constitution. A threat arises to the unity, integrity and sovereignty of the country, and the general public also starts to feel insecure. In such a situation, it becomes the duty of the state to take all measures to protect the unity, integrity and sovereignty of the country. To deal with these special circumstances, amendments have already been made in the Indian Constitution. Students, you might be thinking about what is the situation of emergency. Yes, this is a difficult situation which arises threat to the unity and integrity of the country, and the people of the country also feel that they are insecure in that country. So, there is a situation of social disturbance also. In such situation, it becomes the duty of the union government that it takes all the measures to protect the unity and integrity of that country. Luckily, Indian Constitution have such provisions in it. Emergency provisions. The Constitution of India confers extraordinary powers on the President to deal with the following three types of emergencies. First is national emergency, which is expressed by Article 352. Another one is state emergency under Article 356, and finally financial emergency, Article 360. Let us consider them and discuss them one by one. A. National emergency, Article 352. Under Article 352 of the Constitution of India, the President can declare a state of national emergency if he is of the opinion that by reason of war or external aggression or armed rebellion, the security of India or any part thereof is in danger or such danger is imminent. Students, threat to national unity and integrity is a very serious matter, and the President of India has to take immediate action. This type of action is taken by him under Article 352. When he believes that it is threat to whole country or any part of it, he takes action under Article 352. With a view to prevent the misuse of Article 352, necessary arrangements were made in this regard through the 44th Constitutional Amendment in April 1979, and now the status of these emergency provisions is as follows. An emergency under Article 352 can be declared by the President only if the Cabinet so advises to the President in writing. Emergency cannot be declared only in the name of internal disturbance, but now such emergency can be declared only when there is war, external aggression or armed rebellion, or there is a possibility of it. Students, when some powers to counter the external threat or any emergency situation is provided to the President, it becomes necessary that there should be some safeguards which can stop the misuse of these articles. So, in 1979, a constitutional amendment 44th was introduced to safeguard the misuse of these provisions, and we have to discuss this article in light of Constitutional Amendment 44th, according to which now the President can only declare the emergency on the written advice of Cabinet. Before that, it was possible only due to his discretionary powers, but now it has been made mandatory for him to get the written suggestions from the Cabinet. Similarly, Article 360 cannot be imposed only on the verge of due to internal disturbance, but now it can be imposed only in the situation of war, external aggression or armed rebellion. The proclamation of emergency must be approved by both the houses of Parliament, special majority, within 1 month from the date of its issue. After the 44th Constitutional Amendment, now the emergency declaration implemented by the President has been made justifiable. Emergency can be declared for the whole country or for one or some parts of the country. Students, it is worthwhile to discuss some more provisions regarding it. Now, emergency has to be approved by both the houses of the Parliament, and with the special majority, it means 2/3 majority of present and voting members of both the houses, and if such resolution is not confirmed or approved by both the houses in time period of 1 month, it automatically appears to be expired. Similarly, now the emergency imposed by the President can be challenged in concerned court also, and before the amendment, emergency could be imposed for whole country only, but now the amendment has been made that President can impose such emergency any part of country also. Effects of national emergency. The proclamation of emergency has drastic and wide-ranging effects on various aspects of the political system, which can be discussed under following points. A. Center-state relations. While a proclamation of emergency is in force, the center becomes entitled to give executive directions to a state on any matter. The executive of the union gets the power to give directions to the states as to how they should exercise their executive power. The Parliament becomes empowered to make laws on any subject mentioned even in the state list. The President can modify the constitutional distribution of revenues between the center and the state. Students, if you see the center-state relations, we see that these emergency provisions affect all the three aspects, I mean legislative, executive and financial of the center state relations. If you take the executive field, the union government becomes entitled to direct state governments. How should they exercise their executive power? In the same manner, the parliament can make the laws on the subject mentioned in state list in normal situation which are not available for the parliament to make law. In the financial field, we see that the president can postpone that system, prevailing system, which distributes the revenues between center and state. Effect on fundamental rights. While a proclamation of emergency is in force, the 6 fundamental rights under Article 19 are automatically suspended. The 44th constitutional amendment provided that if emergency is imposed due to war or external aggression, then the freedoms provided by Article 19 can be suspended or abolished. But if emergency is imposed due to armed rebellion, then the provision of Article 19 cannot be suspended. Article 19 is automatically revived after the expiry of the emergency. Students, fundamental rights are very important elements in Indian constitution, and abolishing them is a very serious action. So, after 44th constitutional amendment, it has been established that these fundamental rights can only be suspended when there is a emergency situation due to war or outside aggression, and in case of armed rebellion, these fundamental rights cannot be abolished or suspended. After the 44th constitutional amendment, the president will not have the power to suspend the right to life and personal liberty provided by Article 21. That means Article 21 cannot be suspended in future. Thus, during national emergency, remedial measures are suspended and not the fundamental rights. During emergency, only those laws and the executive orders issued thereunder are protected from challenge in the court, which are related to the proclamation of emergency and not other laws. Student, you see that right to life and personal liberty provided by Article 21 cannot be suspended, and remedial measures which are provided to the citizens as a right to make their appeal in court to protect their fundamental rights is also sometimes can be suspended. Effect on the Lok Sabha and State Assembly. While a proclamation of emergency is in force, the life of the Lok Sabha may be extended beyond the normal term for 1 year at a time. This extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. The parliament may extend the normal tenure of a state legislative assembly by 1 year each time during the national emergency. If parliament is not in session, then the president can issue ordinance on state subjects also. Students, if we talk about the life period of Lok Sabha and state legislative, we see that in the time of crisis or when the national emergency is in operation, then the time period of Lok Sabha can be increased by 1 year. Similarly, the time period of state legislative can also be increased by 1 year. And students, when national emergency is imposed, the president can issue the ordinance on the subject which are mentioned in state list. Revocation of proclamation. A proclamation of emergency can be revoked by the president at any time by a subsequent proclamation. Such proclamation for revocation of emergency does not require parliamentary approval. Apart from this, the declaration of emergency can be abolished by the simple majority of the members present and participating in the voting in the Lok Sabha. The meeting of the Lok Sabha will be compulsorily called on the demand of 1/10th member of the Lok Sabha to consider the emergency. Student, imposition of national emergency is very serious position. So, we have to, it will be worthwhile to discuss how it is revoked. President can revoke this situation by just a simple order, and if you see this process in the Lok Sabha, then only 10% member of the Lok Sabha can call for a such meeting of Lok Sabha to revoke this emergency provisions, and president has to call such meeting on the request of only 10% of Lok Sabha members. Declarations of national emergency made so far. The national emergency under Article 352 has been proclaimed 3 times so far in India. Student, it might be interesting to know when and how this and on the which grounds this national emergency has been imposed in India so far. The first declaration of national emergency was made in October 1962 because of Chinese aggression in the Nepha and Ladakh, and this emergency was enforced till January 1968. Student, this was the time when China attacked India in Nepha. Nepha stands for Northeast Frontier Agency, and now it is known as Arunachal Pradesh after 1987, and this emergency was imposed at that time. The second proclamation of national emergency was made in December 1971 due to the attack by Pakistan. In 1975, when the emergency was already in operation, the third proclamation of national emergency was made in the wake of internal disturbance. Students, in 1975, it was the most disputed decision of that government, which was when the national emergency was imposed due to the grounds of internal disturbance, and at that time the second emergency imposition was already in process. So, it was third time that this internal on the base of internal disturbance this national emergency was imposed. B. The state emergency, Article 356. Article 356 is commonly known as President's Rule. According to the Constitution, the federal government is entrusted with the responsibility to protect each state from external aggression and internal disturbance, and to ensure that the government of each state is carried on in accordance with the provisions of the Constitution. If the President is satisfied that the government of a particular state cannot be carried on in accordance with the constitutional provisions, then in such cases the President assumes control of the state's administration and can dismiss or suspend the state government. This is another type of emergency, and which is especially related to the states. You know that the union government has duty to protect the every state from not only the outside aggression but internal disturbance also, and union government make it certain that administration of each state should be in accordance with constitutional provisions. So, if anything seems to be going against or wrongly in the state, then President can impose this emergency, and that is why it is known as President's Rule. Grounds of imposition. The President's Rule can be proclaimed under Article 356 on 2 grounds. A. If the President is satisfied that a situation has developed in which the government of a state cannot be carried on in accordance with the provisions of the Constitution. Student, it is necessary to be held that the governance system of state should be in accordance with the Constitution. So, if it does not happen, then President becomes entitled to impose such emergency. B. Whenever a state fails to comply with or to give effect to any direction from the center, it will be lawful for the President to hold that a situation has developed in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. Student, if union government give direction to the state and it does not comply with that, that President assumes that a situation has arisen in which President's rule can be imposed in that state. Parliamentary approval and duration. A declaration imposing President rule must be approved by both the houses of Parliament within 2 months from the date of its issue. If it is not accepted by both the houses of the Parliament before this period, then this declaration will be considered expired. If the Lok Sabha is dissolved during such time, or if it is dissolved within 2 months from the date of issue of the act, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution. Students, when a President's rule is imposed in a state, it has to be approved by both the houses of Parliament within the time period of 2 months. If it does not happen, then it is considered to be expired. Suppose if there is no occasion of approval it due to the dissolution of the Parliament or Lok Sabha, then what happens? Then it is in force till the Lok Sabha is reconstituted, and after 30 days it is has to be approved, and if does not happen it is deemed to be expired. After the period of 1 year of the president's rule in the state, the proposal to continue it for more time can be passed by the parliament only if at the time of passing such a proposal the crisis period under article 352 is in force, or the election commission proves that it is not possible to hold elections in the state. Students, if there is a situation then where the article 352 is in force, then parliament can increase the time period of this president's rule in any state. And second position, when election commission proves that in that situation the elections is not possible to be held in that state, only then the time period of this president's rule can be increased by 1 year. Effects of the president's rule: the president can declare that the legislative power of a state shall be exercised by the parliament. He can take up the functions of the state government and powers of the governor or any other executive authority in the state. For the purpose of the proclamation, the president can take all other powers in his hands except the power of the high court. Students, it is necessary to mention that except the high court powers, president can take all the legislative and executive powers in hand at the time of imposition of this type of president's rule. Effect of the president's rule can be seen in other manners also. The president can order expenditure from the consolidated fund of the state when the Lok Sabha is not sitting. During the period of crisis, the president can impose restrictions on the freedoms provided by article 19 of the constitution. The right to constitutional remedies can also be restricted in respect of rights other than life and personal liberty. Students, if we talk about some other provisions regarding president's rule, we see that president can make expenditure from the consolidated fund of the state, and the restriction can be imposed on the freedoms provided under article 19. Similarly, the right to remedial the constitutional remedies also is postponed in this time period. President's rule in practice: the president's rule has been used for more than 130 times in India so far. In the history of independent India, most controversies have arisen regarding article 356, because political parties assess this article in the context of the ruling party and the opposition according to their own political gains. Hence, there is a possibility of continuous controversy. Even after adopting the federalist system in India, it was considered necessary to equip the center with extraordinary powers, and the constitution makers included it in the constitution even after accepting the possibility of its misuse. The article 356 needs to be re-examined in the context of center state relations. Student, here it is necessary to mention that this is the article which has been disputed in the history of India, because the allegations are levelled against the government in the power that the political parties use this article, or we should say misuse this article for their political gain, and that's why it has become necessary to examine the use of this article by the constitution experts. Third, financial emergency, article 360. According to article 360, if the president is satisfied that a situation has arisen due to which the financial stability or credit of India or any part of its territory is threatened, then he can proclaim a financial emergency. It needs to be approved by the parliament within 2 months. Once approved by both the houses of parliament, the financial emergency continues indefinitely till it is revoked. The president can withdraw the declaration of financial emergency at any time. There has not yet been a need to impose financial emergency in the country. Students, this is the situation when any part or whole India is threatened due to the financial crisis, then president can assume that now the article 360 should be imposed and financial emergency is imposed in situation. Similarly, it has to be approved by both the houses of the parliament within time period of 2 months, and as we have seen that national emergency has been imposed 3 times, and president rule has been imposed more than 130 times. This is, we are very fortunate to say that financial emergency has not been imposed in India till from its conception. Effects of financial emergency. The union government gets the right to give orders to the state government in financial matters. Necessary reduction can be made in the salaries of the officers of the union and state governments. Under this arrangement, the finance bill passed by the state legislature can be ordered to be secured for the approval of the president. The president can make necessary amendments in the provisions of distribution of finances between the center and the states. Students, if we talk about the effects of this financial emergency, we see that union government can give direction to any financial matter to the states. Similarly, the salaries of all the officers, and all officers include the judges of the Supreme Court and high courts also. Finance bills which are passed in the state legislative can be secured for the approval of the president, and the prevailing system of distribution of funds between center and state can also be suspended for some time period in this type of emergency. Emergency provisions criticism. The federal character of the constitution is destroyed and the union becomes all powerful. Students, the allegations are leveled against provisions of this emergency that in time of emergency central government becomes all powerful and the federal character of the country is destroyed. The president can become a dictator. Yes, all the powers are centralized in the hands of the president, and that is another objection. Misuse of emergency provision for political gain. Students, all the opposition parties have been alleging that all these emergency provisions are being used for their political gain and of financial autonomy of states. You have seen that at the time of emergency situations, parliament gets the right to make the laws, especially on financial matters which are allotted to the states. So this is another objection. Fundamental rights become meaningless, destroying democratic foundation of the constitution. Fundamental rights are considered to be the pillar of the rights of the people, but these fundamental rights are also suspended or can be abolished in the time of emergency. So this is another objection. The use of emergency provisions had not been so as per the hope and desire of the framers of the constitution. It is also said by the expert that the emergency provisions were not meant in the way they are being used at present. Suggestions. While criticizing the emergency provisions in the Indian constitution, we should also remember that these provisions provide framework for addressing extraordinary situations. The judiciary has played an important role in defining the contours of emergency powers and protecting fundamental rights during emergencies. Recent amendments to enhance accountability and judicial review demonstrate that the commitment to preserve democratic principles even in times of crisis. Even then, the union government should use these provisions as last alternative to meet out the situations. Before using Article 356, the state government should get a clear warning that it is not governing the state according to the constitution. The governor's report should be led in both the houses of the parliament, etc. Students, here it is necessary to discuss those suggestions which have been provided by the constitutional expert. They say that no doubt the emergency provisions are important, and judiciary has played an important role in defining the format or those situations where these emergency provisions should be used. For example, judicial review, the power of judicial review of judiciary is playing an important role in defining the emergency provisions. According to Article 356, it is said that this should be used as last alternative, and state government should be given clear warning that there should not be any situation for imposition of this type of provisions. They can correct themselves before imposition of these provisions. Conclusion. The system of emergency provisions in federal Indian constitution is unique. These provisions grant exceptional powers to the central government to tackle different types of emergencies. Over the years, these provisions have been tested and interpreted by the judiciary, emergency provisions need to be re-examined in the context of concern for ensuring the unity and integrity of the nation on the one hand, and at the same time protecting the fundamental rights of the citizens and federal character of the Indian Constitution on the other. Students, and as conclusion we can say that while using these emergency provisions, there is a question of unity and integrity of our nation, but at the same time there is question of protecting fundamental rights of the citizens and the federal character of our Indian Constitution. So, we have to re-examine these emergency provisions, keeping in view both the aspect of this the emergency provisions. Thank you.